Good evening and welcome to the Electronic Wills and Online Witnessing Committee's second webinar, and our very first for 2021. I'm Carol Grimshaw, Chair of the Electronic Wills and Online Witnessing Committee, also known as EWOWC, and Director of our parent, the Australasian Cyber Law Institute. Before I hand you over to Paul Reynolds of Council from the Victorian Bar and member of EWOWC, who will introduce you to our esteemed panel of guest speakers, about whom we could not be more thrilled. EWOWC and ACLI gives thanks to the elders past, present and emerging of all of the lands on which Australian guests and participants work, learn, advise and play. Tēnā koutou katoa, which means greetings to you all who are joining so late in different parts of New Zealand and from across Australasia, Las Vegas and even special guests in South Africa. EWOWC and ACLI also gives thanks to our wonderful sponsor Young's List and its Chief Clerk, Tammy Young, who unfortunately couldn't join us today. We thank them for their generous support and friendship and introducing us to Paul Reynolds of Council. It's wonderful to find shared values, and we can certainly say that EWOWC and Young's List are lockstep in serving the community with smart, forward-thinking legal solutions while ensuring great risk management through inclusive yet rigorous standards. Without further ado, I'll ask Paul to moderate our fabulous panel of Registrar Price of the Probate Division of the Supreme Court of Victoria, Julie Steele, Chief Executive Officer of Queensland Courts, Supreme District and Land Courts, Jenny Lowe of Morrison Kent Lawyers in Wellington, New Zealand, and Kimberley Martin, Step Member, Wills and Estate Specialists, Legal Practitioner Director of Royal Moss Martin Lawyers in Hobart, Tasmania, and most importantly, one of our EWOWC members. Paul?
Thank you very much, Carol. Hi everyone, I'm Paul Reynolds. I'm a member of the EWOWC committee with Carol, and I'm a barrister practicing in estates litigation on Young's List. Welcome to this event. My interest really in EWOWC is in what effect the electronic signing and witnessing will have, in particular on contested probate litigation, especially on questions of testamentary capacity, knowledge and approval, fraud, undue influence and the like, and also on the admission of informal wills to probate. So I'm delighted to be your moderator this evening, and so welcome. To explain the format for tonight, we've got panel discussion with our four panellists, whom I'll introduce in a moment. And that'll go for about 45 minutes. After that, we'll have our town hall discussion. The purpose of that is to allow an opportunity for practitioners to talk about their experiences and work through some of the questions and some of the teething issues that no doubt we're all somewhat familiar with so far. And with this new, perhaps uncomfortable way of executing wills. So unlike last time, the town hall discussion, to help things run smoothly, the questions have been pre-registered. So I'll be calling on people to ask those questions. And now I'd like to introduce our panel. First up, we have Registrar Kate Price. Registrar Price was recently appointed the Registrar of Probates at the Supreme Court of Victoria, having been appointed in December 2020. Registrar Price is going to discuss everything you wanted to know that's gone wrong about electronic probate in Victoria, but were afraid to ask. Now, when I became an associate to the judge in charge of the probate list in the Supreme Court of Victoria in 2012, Registrar Price was already the person to ask if you had a tricky or arcane question. It seemed that even then she had come across every problem that you could possibly have. So I'm very interested to hear in just what she has to say tonight with an extra 10 or so years of experience behind her. Our second speaker is Julie Steele. Julie is zooming in from Queensland, where she's the Executive Director at the Supreme District and Land Court Service at the Queensland Courts. And Julie is going to tell us about the electronic changes that have affected their state at the Supreme District and Land Court Service. Our third speaker is Jenny Lowe. Jenny is a specialist in probate at Morrison Kent Lawyers Wellington in New Zealand. From her entirely COVID-free outpost in Wellington, Jenny's going to tell us about the state of electronic signing and witnessing in New Zealand. So we're very lucky to be receiving an international perspective in what is clearly becoming an international issue. And our fourth and final panellist is Kimberley Martin. Kimberley is a director of Worrell Moss Martin Hobart in Tassie, where she specialises in, amongst other things, all estate matters. Kimberley is also a member of STEP, the Society of Trust and Estate Practitioners, and in 2008 she was awarded the Young Practitioner of the Year at the STEP Private Client Awards in London, and that, I note, is an international award. Kimberley is going to discuss the state of electronic signing in Tassie and no doubt mention Tasmania's Power of Attorney Registry, electronic registry, and she'll also be sharing some of what she's learnt about the developments in other common law jurisdictions, drawing on her experience as a member of STEP. So without further ado, I'd like to introduce Registrar Kate Price to tell us about her experiences over the past year with electronic probate at the Supreme Court of Victoria. Kate.
Thank you very much, Paul, for that introduction. It was very kind of you to say nice words like that. I have been in the area for a while, so I've seen a bit of everything. But it's been very interesting, I think, in the last 6 months to be coming across these new types of wills, which are, of course, audiovisual witness wills that aren't informal. So it's been a very interesting time to be in this position of Registrar of Probates. Thank you also to EWOWC for inviting me to talk today. I think everyone would know that the court has been committed to a digital transformation both inside and outside the courtroom, which has most recently been seen with our launch of Registrar Probate to enable the electronic filing of probate and administration applications. And I think that the progress that's been made in relation to that digital transformation across the board as a result of COVID-19 has been a really important step forward and something I hope will potentially stay around for a bit of time in some respects. Before I get on to talking a little bit about what I've seen in terms of audiovisual witnessing of affidavits and audiovisual witnessing of wills, I just wanted to give a little bit of an update on Registrar Probate. The talk was perhaps a bit misleading because from my perspective, although I welcome the profession to correct me, but from my perspective, I think the online probate system, Registrar Probate, has been an incredible success since it was launched on 1st of July last year. And we haven't actually had that many issues arise, which has been really good. I think going digital, there was a lot of concern in the community about what impact that would have. There was a lot of concern about what an electronic grant would look like and whether or not we would have asset holders recognise that electronic grant. But overall, we've seen some really good outcomes from the move to Registrar Probate. Firstly, in terms of turnaround time. So previously, it took about 5 to 10 working days to get a grant from the court. Currently, we're under our new system, we're operating on turnaround times of about 1 to 2 days. If you lodge an application for letters of administration, most of you would know that you get that grant back the same day if you have everything right and you don't have any further information you need to provide to us, which I think is just incredible. I think when we built Registrar Probate, it was really important to us to create a system that created efficiencies, not just a system that was easy to use, but that was efficient from both the user perspective as well as from the internal perspective. And a lot of people don't realise that along with creating Registrar Probate from our end, we actually created a whole new system called the Examiner's Portal, which is what we use to actually examine the applications, to send out those requests for further information and to generate those grants. So that's what we did in tandem, is create those two systems so that we could end up in a situation where we got those really quick turnaround times of 1 to 2 days. The other really great thing is it has enabled electronic court files for judicial officers, which is really, really important. Previously, we used to be in a situation where if you filed an affidavit at 3 p.m. on a Thursday when your directions hearing is at 9 a.m. on a Friday, it might be that that affidavit might not actually get to the judge in time for them to consider that before the directions hearing. It still might not be time, so please don't take that as a suggestion that you should file affidavits at 3 p.m. on a Thursday when your hearing's on Friday morning. But the great thing is now that we've got electronic court files, the judicial officers can be assured that what they're looking at on their screen is exactly what's been filed with the court and everything is completely up to date. The other really good aspect of Registrar Probate is that it obviously enabled us to do working from home arrangements during COVID-19. When we first had COVID-19 hit in March last year, we were still operating with paper files. And that was quite a challenge. It sort of involved a lot of couriers moving files from the court to people's homes and then back again. And it's interesting because I think now that we're online, obviously the examiners, the assistant registrars are able to work at home. One of my assistant registrars funnily said on the second day that we went live, I think this is the first time that probate has ever been granted from someone's garage. So it's been a really interesting time to be working through it. Just in terms of numbers, so far we've had 13,838 applications filed since 1st of July, and we've issued 13,178 grants. And we have had hardly any issues in terms of asset holders recognising those grants. And that's probably due to a lot of work we did in advance of launching the system, trying to get people, trying to get the banks, land titles office, those big sort of asset holders that a lot of people deal with when they get probate and administration. We got them on board and made sure they were aware of all the changes that were coming. So there hasn't been many issues in terms of asset holders recognising those grants, which has been fantastic. I think overall, not just asset holders, but the profession have adapted to that technology really well. They've adapted to being able to use Redcrest Probate and have found it fairly straightforward. There were some teething issues at the start, but I think now we're all in a rhythm. And I think overall it's been a really interesting time because there's been a huge need for the profession to adapt to new technology, not just Redcrest Probate, but obviously with the new introduction of legislation and regulations that allow for the audio-visual witnessing of affidavits, the audio-visual witnessing of wills. The profession was thrown into a situation where they quickly had to learn a lot of new software, a lot of new programs, and figure out how they would do that witnessing. I know that when this first happened, I sort of explored the idea of whether we could assist self-represented litigants by audio-visual witnessing of affidavits, and the technology was very difficult for us to arrange. So I can only imagine how much effort has gone into that by all of the solicitors firms that have adapted. Quickly, I mean, I'm here to obviously answer some questions later on, and I want to focus on that, but I just quickly wanted to talk about some of the things that I've observed in relation to audiovisual witness affidavits, audiovisual witness wills, to give you a bit of, I guess, some pointers about what to look out for and what to try and avoid in terms of audiovisual witnessing. Firstly, in terms of affidavit, I think the main issue that I've seen is that basically there's a lack of information in the jurat, which is actually required under the Oaths and Affirmations Act. So I would encourage everyone who's going to audiovisual witness and affidavit to double check those requirements in the Oaths and Affirmations Act and what you actually need to endorse in the jurat. Another problem that comes up frequently is that a lot of people state in their jurat that they're witnessing the affidavit audiovisually in accordance with the COVID-19 electronic witnessing and signing regulations. And that's not the case. You're witnessing an affidavit audiovisually in accordance with the Oaths and Affirmations Act. So it's important to double check if you do have precedents, what your precedents say, and that you're referring to the correct legislation in terms of what's actually empowering you to witness the affidavits in that way. In terms of audiovisual witness wills, which is what I think everyone is probably interested to hear about, so far we have had 7 applications filed with the probate office in relation to audiovisual witness wills. Unfortunately, none of those applications have actually complied with the regulations, and all of them have proceeded as on the basis that they're an informal will and will need to be assessed according to Section 9 of the Wills Act, which is a shame. But I think reading the regulations, there are quite a few steps that are required, and you sort of have to read through it a few times to make sure that you're complying with every single step. And if you are going to audiovisual witness a will using the regulations, it's really important, I think, you read through that and make sure you understand exactly what all of those steps are. Because if you do, I mean, the good thing is that we've got the remedial Section 9 provisions. So if it isn't witnessed correctly, then we can rely on Section 9 of the Wills Act to admit that document to probate as an informal will. But obviously there's a couple of issues with that. you're probably not going to have many issues in terms of proving intent because you almost got it over the line in terms of witnessing it as a valid will. So the intent issue is probably not going to be as difficult to prove as it would be if, for example, it was just a document that's been signed at the tennis by someone while they've been watching the tennis. But you do have the issue that if it becomes an informal will, you have to provide testamentary evidence. So you have to provide evidence as to testamentary capacity in relation to the testator. And that can be difficult if the person hasn't been assessed. All of the ones that have been filed so far, only one of them has been granted so far. The rest are still pending. And that's because the majority of times they're having difficulties with getting that medical evidence. So it is really important that you try and make sure that the will has been executed correctly. The other potential issue that you face is that you might be in a situation where it adds costs to the estate in relation to proving that will. Obviously, for those that don't know, the Registrar of Probates in Victoria has power under Section 9 to admit documents to probate if the value of the estate is under $1 million or over $1 million if there's consent of everyone who would be affected by a decision. But in any situations where it's over $1 million and there's minors or there's people under a disability, then that will have to go to a judge of the court for assessment. And that's obviously going to add time and delay in relation to processing the application and potentially going to add cost as well. So I think it's really important for anyone who's considering audio-visually witnessing a will to make sure that you're doing it correctly. In terms of what's been wrong so far, what I've seen and what I would suggest is probably the biggest, the two main things that have been problematic with all of the applications that have come through. Firstly, the majority of them, I think out of the 6 of the applications that have come through didn't comply with regulation 41(5)(f). And that's the requirement that after the will has actually been witnessed by everyone, it goes back to the testator and the testator prints it out, for example, and actually endorses on it that it's been signed in accordance with the regulation and signs and dates that. And that hasn't been there on 6 of those applications. And it's really important that that's actually complied with. The other issue has been in relation to a bit of a weird wording in the regulations. And that is that the regulations require that an endorsement by each of the witnesses of a statement that it's been witnessed in accordance via audio-visual link. The thing with that is that it has to be, that statement has to be actually witnessed via audio-visual link at the time that the witnessing is done. So it has to be written at that time. And in a couple of instances I've seen, it's been endorsed on the will, but it's been endorsed there before the actual signing. So for example, if someone has been using DocuSign to actually witness the will, that statement has already been on the will before it's been provided to all of the parties to actually sign. And as a result, that's made it an informal will because it hasn't complied with the regulations. Now, I know that this seems like finicky little things. And I have had a couple of solicitors actually contact me and say, well, you know, can't you just overlook the fact that that particular regulation hasn't been complied with? But unfortunately, I don't have power to do that. The court doesn't have power to do that. We can't overlook the legislative requirements in relation to what constitutes a validly executed will. But as I said, we do have those remedial provisions in relation to Section 9, so we can look at it as an informal will. I guess what I'd like to finish off on, because I'm aware that we need to get to everyone else to talk to, and I will obviously answer any questions that anyone has. But what I would like to finish off with is just to give some advice. And that is basically that if you have audio-visually witnessed any wills so far under the COVID-19 regulations, please revisit those and please make sure that you have complied with every single step of those regulations, every single condition that is outlined in the regulations, and complied with it strictly, because that's what is required in relation to making sure that it's a validly executed will. If you have any doubt at all and the person is still able to, then I would suggest that you might want to contact your client and just potentially re-execute that will if you have any doubt at all about the validity of that will under the regulations. So happy to answer questions once we get to the end, but hopefully those few little things have been a few tips to look out for when you're audiovisually witnessing affidavits and wills.
Thank you very much, Kate.
Thank you.
I certainly do have a question for you, but I'll wait for the town hall discussion to begin, and we'll move now to Julie, who can tell us about the situation in Queensland.
Thank you, and I'm very grateful that you invited me to be here today. I was admitted to practice 32 years ago, which probably makes me a little bit older than Kate. And during the first 10 years after my admission, I had quite a significant wills and estates practice before I went into the public sector. My role as the executive director actually is accompanied by the fact that I'm multitasking, which is pretty common here in Queensland. I'm also actually the principal registrar of the Supreme Court, and the probate registrar reports to me. So what we tend to do is when it comes to discussion about policy, or when the probate registrar gets a bit stumped, she'll come to me about probates. So hopefully I can give you some insight into it. And I'm also very keen to hear what people's experiences have been, what insights they can offer me, and very interested to hear about other states and jurisdictions. In March 2020, Queenslanders became alert and alarmed about the potential impact on our ability to undertake essential tasks in the event of a COVID pandemic manifesting in our community. Suddenly there was a plethora of well-informed and not so well-informed advice about the desirability of as many people as possible working from home, and the need for those in certain vulnerable groups to undergo self-isolation to preserve their own lives. I think it's hard to underestimate the degree of panic that was in the community as a whole, I think, in March of last year. The COVID-19 pandemic was possibly going to overwhelm our community any day, and we had no time to think too much because we needed to act. I therefore got to do quite a bit of consultation with the legislative arm of government. Overwhelmingly, the groups identified as most at risk consisted of many of those likely to be crucially aware of the need to put their affairs in order by attending to issues such as having an up-to-date will. Of course, this was happening all over Australia at the same time, with each jurisdiction scrambling to develop a legislative framework that allowed vital legal tasks like making and updating wills to occur in a world where the lawyer and their support staff were doing the right thing by not being with their client or even together, and everyone usually involved was not in the same room. Technology options were suddenly urgently considered. And I understand, of course, that some states decided not to go to the cutting edge here, and they just withdrew from the discussion about that because there were a lot of very tricky policy issues, including issues like the accessibility of the technology to the elderly and other relevant groups. But there wasn't much time to undertake the usual lengthy consultation and research processes to arrive at viable legislative responses. So hence we've got quite a divergence, I think. There also wasn't much time for policy officers to consult with each other. In my research, I was assured that by the time Queensland's, and this is very snappy, Justice Legislation COVID-19 Emergency Response Documents and Oaths Regulation 2020, it rolls off the tongue, was introduced, the policy folk had had a brief opportunity to look at New South Wales' effort, but not much more. While I haven't carefully examined the legislation of every other state, I am assured by those that have that there is an unsurprising degree of commonality. After all, the predicament, fears and options facing each jurisdiction was pretty much the same at the same time. But what I am assured is that one of the significant areas of variance between Queensland and other states was in the provisions about the execution of wills and documents altering, revoking or reviving a will. Now, I don't propose to go through all the legislative provisions because it's very boring apart from anything else. There's quite a lot about substitute signatories, but basically one of the first crucial concepts I think in the legislation is at Section 5 of regulation, and it provides for the concept of a special witness. And a special witness is defined as an Australian legal practitioner, a JP or Commissioner for Declarations approved by the Chief Executive, a JP or Commissioner for Declarations employed by the law practice that prepared the document and who witnesses documents in the course of that employment, or a notary public, or if it's a will or codicil prepared by the public trustee and the person is employed. So crucially, for any one of these audiovisual witnessing requirements, there's got to be at least one special witness. So that's the first criteria, I think. Basically, it can only be done by audiovisual link, and from what Kate was saying, I get the impression that's the same in Victoria, but I think it's somewhat different in some of the other states. I'm just not sure about that. basically, I think one of the differences between what Kate was describing and what happens in Queensland is that, yes, there must be a confirmation of the document and a certificate that goes with the will, but they don't have to be signed on the same day. They can be signed as soon as practicable after witnessing, okay? But what then happens is that at least one special witness must be present, and that special witness must do a certificate under section 21 of the regulation. And that certificate has various criteria in it. It seems to be the default setting that you don't need to change the attestation clause in the will, but you do need to have the certificate, because the certificate talks about saying that the document was signed and witnessed during the regulations period, that it was signed and witnessed in accordance with the regulations, the steps that the special witness took to verify the identity of the signatory, the process followed for signing and witnessing the document, that they are a special witness, and whether any recording was made under section 26 of the regulation of the signing and witnessing of the document, and any other matter that they think relevant to the signing and witnessing of the document. As I said, there's only one. If there's two special witnesses, only one of them has to do that certificate. Interestingly, we don't have that provision that Kate spoke of, where that certificate, or the equivalent of it, I think in Victorian law, has to be confirmed essentially by the testator. I think that's what Kate was saying, was that it has to be adopted essentially by the testator. There's no requirement for that, but there is a requirement that the will is given to a person for either back to the testator or to another person as directed by the testator, with the section 21 document attached to it. So it's got to be kept with the will at all times. So I think those are the main differences. One of the other things that I think that's happened that's been very helpful is that the Queensland Law Society has issued a form of certification to assist practitioners. So they've actually done up a precedent to assist practitioners in getting that certificate right, which I understand has been very welcomed and useful. Unlike Kate, we've considered one will executed by audio-visual means, but it was successful. So that's a 100% success rate for us. There are some differences, though, I think, in our context, which really need to be taken into account. The first is that we haven't actually been significantly affected by actual instances of COVID. People haven't, apart from some brief periods, people haven't been working from home to the same extent as they've had to in Victoria. We haven't had very many cases, and the registry, for example, has remained open the whole time. We've never closed the registry at any time since COVID was announced, because we haven't had to. So that makes life, I think, much easier, which is a big relief as well, because we have no electronic case management system, but we're doing something which is the equivalent of chewing gum and string, but I'm hoping it's still going to be pretty good. But we might get an electronic product in a year or two. The product we are using, and we'll be launching this for all legal practitioners only, not for self-represented applicants, on Monday, is using a technology called Objective Connect. It's rated as secure by ASIO and has a virtually unlimited capacity on document size. It's essentially the vehicle by which we can securely receive and return documents. So all a lawyer needs to do to use it is to register once. They then get allocated their private workspace, and that can be used for all of their applications thereafter. We've had tons of support in the very low-tech pilot that we did from the profession and acceptance by asset holders. I also thank Victoria and places like South Australia for making that possible, because I think people like many of the major asset holders like banks and etc. have started to get used to the idea that they'll only get an electronic form of probate, and that's really actually possibly better than the physical document. The first phase of the pilot was using dummy documents. The second phase of the pilot was using actual court documents. It's limited to applications for grants and probates of probate and letters of administration. And the reason is that these files only have one party and they rarely go to court. They constitute a significant portion of the civil documents we receive in the registry, and it's not a suitable product though for urgent or time-sensitive matters such as caveats. The Objective Connect product is used only for lodging documents. But that doesn't mean that they're automatically accepted. We're not that sophisticated. I don't know how sophisticated request is. And so basically what really happens is it looks a bit schmick at the front end, and then we get it into we go into that site and we basically pull the documents out and put them into our case management system, which isn't electronic. So that we still have the discretion to not file a document. So once we've reviewed it, we can basically say, no, it doesn't meet the minimum requirements, or here's the fee, etc. We can accept the fees electronically. We do not print documents, though, that we receive electronically at all. And we've developed electronic sealing and signing processes. The documents actually taken by the registry from the platform, as I said, and they only remain accessible in Objective Connect for 60 days for storage reasons. It's not meant to be a repository or quasi-case management system. Actual applications, however, can be seen on the eSearch website once we've received them, so you can just go on and look it up. And other documents are only listed on that index, but not able to be read there. If there's a will, the original must be delivered by hand or post, which I think is very similar to Victoria and most other states. But we can simply compare original will with the electronic file and then send it to the file room. So that's the only document we have on the file. The entire matter is considered electronically, and if we approve, we issue the order electronically. The grant is only created electronically and is then accessible on the eCourts website, which we've had for some time. It's proven valuable, albeit extra clunky. We don't think it's extra clunky from the point of view of practitioners, but we're going to see as of Monday, because we've only done 62 so far. So we'll see how we go after that. We developed protocols and a user manual to guide the parties on how to name the documents, etc. The feedback from participants has been very favourable, and they want it to continue for probates, and they want us to expand it. And we're kind of going, it's actually not that schmick at the back. So we've got some reservations about that. While it isn't high tech, it is effective. What it does do is it abbreviates our process compared to paper documents by a week. So you can get it within a matter of a couple of days if you do it electronically. Otherwise, it'll take you a couple of days plus a week. One of the other things that I think is important to mention here is that, so that's where we're going with it electronically. However, another thing, as I said, COVID hasn't actually hit us. One of the things we've identified in Queensland, bizarrely enough, is that actually the deaths generally across Queensland have decreased during COVID. So have our probate applications. We've actually had, it's been amazing, the alignment. In the last 6 months to 2020, there were 10% less deaths and there were 10% less probate applications. So I'll leave you with that thought. Or rather ironic, it's actually been less fatal. Thank you.
Thank you very much, Julie. And we're going to move, we're moving all over the place at the moment. We're going to Jenny across the Tasman Sea in Wellington. Over to you.
Perfect. Well, so welcome to windy Wellington. I call it the probate capital of New Zealand. My name is Jenny, and I work at Morrison Kent, as well as doing general estate planning and trust administration. We also run a service called NZ Probates and Reseals, where we deal with everything from difficult or foreign applications right through to simple local applications for practitioners who either see them rarely or just hate them. I am apparently, according to our High Court, one of the few or only people in this country who are crazy enough or genius enough, I'll leave that one to you, to specialize in probates. So I'm going to take you through the New Zealand experience during lockdown, and I'm already learning that, well, some similarities and some differences, I suppose. In New Zealand, again, the entire outbreak has affected us, so much less than so many other parts of the world. And we really only had one big, what we called level 4 lockdown. And really, in the grand scheme of things, it wasn't that long. So I'll take you through our experience, or at least my experience, of signing of wills, enduring powers of attorney, also the probate practice in terms of our probate unit, and also signing affidavits remotely. So Yeah, so in terms of wills and enduring powers of attorney, as soon as the big lockdown hit in New Zealand, nobody left their houses at all, except for you could go for groceries and you could go for little exercise walks, but there was really no way for 3 people to sit in each other's presence and in the presence of all 3 and watch signing a will at the same time. So what we did to begin with, when we really had nothing to go on, was we prepared all the wills for our clients. We emailed the draft to our clients and we said to them, could you please email back confirming that this will is to your satisfaction and that you would sign it if you could. Essentially just preparing for a court application to ask the court to validate that will. And that was our initial position. Happily, our lovely government brought in the Epidemic Preparedness Wills Act 2007 Signing and Witnessing of Wills Immediate Modification Order of 2020. I feel that they didn't have enough time to give it a snappy name. I'll just call them IMOs. We had a number of them for different things. I'll call them IMOs for ease of reference and so that I don't bite my own tongue. This modified our Wills Act so that the will could be signed by the testator and witnesses via an audiovisual link, very prescribed to only while that high lockdown was in place. And it seems to be a lot simpler, really. It was each of the witnesses would be with each other over the audiovisual link, and it had to have a screen that you could see everybody. All 3 would sign, and then immediately upon signing, they would photograph or scan the 3 copies of the will and send those 3 copies to one holder of the will, which was almost always the lawyer, who would hold those copies. As soon as we came out of the lockdown, these wills were perfectly valid according to our law, but out of an abundance of caution, me and I think quite a few other practitioners just got them all re-signed, just so that when we did get around to probate, I mean, if possible to re-sign, but when we did get around to probate, they'd be easier to manage. So an interesting example was a situation I encountered when signing enduring powers of attorney with a client, and we had an IMO to allow that over audiovisual means. So, I mean, Zoom's been very good in terms of I could just email a link to my clients, and even if they didn't know how to use it, they just click the link and Jenny would appear on their computer, which was quite good. That worked quite well. But this particular client was in her late 80s, and although she could understand the concept of it and sign it, she wasn't able to understand where the camera was, where to look, and she wasn't able to understand to point the camera at the documents, so that, because we had to a requirement where we had to check that she was in fact signing the document that I in fact sent to her. In the end, under normal circumstances, I would have sent her attorney out of the room in order that I could have a close personal chat with her and just make sure that she wasn't under any pressure. But in this case, we had to call the attorney back so many times to fiddle with the technology that in practice, he was there for the whole thing. And as soon as I'd done it, I actually found out from her children that they were very concerned that she was signing the document under pressure. Although they said to me, if I'd met her in person, her personality was such, she probably would have said it was fine anyway. Luckily, our enduring powers of attorney aren't valid until all the attorneys have signed it. And one of the things that made me more comfortable was she'd appointed all of her children as successor attorneys. So they didn't sign the document. The document didn't become valid. And in the end, we were able to sort the matter out just a different way. In terms of our probate practice, all of our probates are done through one central registry in Wellington. And the entire of New Zealand conforms to exactly the same standards. During lockdown, our probate unit found out that they'd never really had any reason up until then to have a large and coherent system that allowed them to work from home. And so they actually had no ability to work from home. A few of the registrars had it sort of, certainly enough to look after us in the meantime. But again, our initial position at the level 4 lockdown was that our probate unit had limited access to their own systems, and we had limited access to them. Pretty much everything ground to a halt from that point of view. Although, again, all the registrars made themselves available and just worked through really on a completely case-by-case basis. Yeah, so essentially things became very busy on a number of levels, and reading between the lines, they worked through day and night to implement a system that allowed them to work from home completely from scratch, really, and with an inability to leave their homes to sort it out. And there was lots of special dispensations given and assistance to us practitioners as the urgent ones came up, which they inevitably did. As soon as the probates unit were up and running again remotely, we got another IMO, which changed our Oaths and Declarations Act. And it allowed people to take an oath when the oath taker was not in the physical presence of the person actually signing. However, our probate unit didn't accept remotely signed applications, and their process, it didn't really matter because their process requires that certainly the whole application is delivered to them in paper form, but importantly, the original will. So it's you know, they need to do all those things that they do with the original, which are very important. Essentially, even if we could have posted the wills to them and the postal system went very slow suddenly, they weren't actually at the probate unit. So there was really nothing that could be done for that, other than all of the urgent ones were given special dispensations to accept remotely signed affidavits and to send the application to them by email, with lots of contact with the lawyer on a case-by-case, almost personal basis to make sure that everything was as in order as it could be. It all ended well, mind you. Our probate unit ended up with a good system now for working from home, and they called in extra assistance from around the country to clear the backlog, as there was a huge backlog as soon as lockdown lifted. It's only about 10 years ago that all the probates came into Wellington, so there's that knowledge in all the other courts. And in the meantime, they've actually shaved weeks, sometimes months, for the tough ones off the time it takes for them to grant probates. So it was a happy ending for that. In terms of the actual signing of affidavits, as I said, to begin with, we were just simply unable to sign any of them. And then when the IMO came in, for probates, they were accepted, but urgent cases only and with permission only. And yeah, the way we did it was the two people could be, in this case, it could be an audio-visual link. It could also just be an audio link, but the person taking the oaths had some extra jobs to do. They had to make sure that the person was the same person that was signing the document, and they had to make sure that person had read and understood its contents and that all the exhibits were the same exhibits noted in the document. If you didn't already know that client well, this often required quite a few extra steps, such as ensuring the audio link was good quality, getting reliable photographic identification, pointing the camera at the documents, depending what you were doing, to make sure that everybody was signing the same thing. I did need the probate unit's special permission more than once during lockdown, and one of them, it was a client who was found dead the day before we went into level 4 lockdown on his rural property in pretty much the middle of nowhere with an unpaid mortgage sitting on it. And his appointed executor under his will had been traveling and was stuck in Thailand with no means of getting back, no operating postal system to speak of. it was a head scratcher. In the end, I got permission to take his affidavit by audiovisual link, and it was really difficult to get the link of a good enough quality that I could make sure I knew who I was looking at. And all he had was a mobile phone. So holding it at the right angle so I could actually check that it was the correct document and that he was signing in the right places was actually quite difficult. In the end, we succeeded, only to discover when the original will finally got sent to me that it was invalid and we needed to make a totally different application. But good learning, good learning. And in the end, the son of the deceased was able to apply for letters of administration, and he lived in Wellington, which was fine. I think as some parting thoughts, this was a fun ride in terms of paperwork. Terrible on so many other levels, but for we who love probates, it was great. I think we're also quite relieved and very, very lucky to be as much back to normal as we are. All of those IMOs have expired and none of this happens. It happened for a very short period of time. I guess the thing that I think about is that all of these different checks and balances and procedures have been, they've been based on hundreds of years of evolution of this type of system. If we do end up doing this again in New Zealand, or indeed move on to any sort of more permanent basis for electronic signing, they need to reflect each and every one of those reasons in their own special and different modern way. Thank you really for inviting me to speak. I've already learned a lot, and it's a real honor to be part of this conversation. I'm often telling people that probates are the only vestige left of the medieval writ system. And the way I look at it, if this system can survive since knights in shining armor, I mean, they've seen the bubonic plague come and go. With all of us working together like this, it can overcome little thing like COVID-19.
Thank you very much, Jenny. It seems that our jurisdictions share a lot more than just cumbersome names for legislation. So we're going to move now back across the Tasman to Hobart, where Kimberley is going to talk to us about the system in Tasmania. Kimberley.
Thank you very much. I think one of the most important things to start on, and why somebody in Tasmania is talking about electronic wills and remote witnessing when we don't have any legislation at all, unlike other states and territories in Australia, is because I wrote a paper on electronic wills in 2019, before the outbreak of COVID-19, and I went to London because I sit on an international board that deals with digital issues and how countries around the world are progressing in terms of digital assets and electronic signatures, with a particular focus on wills and estates. So I stood in front of about 150 people and I said that electronic wills and remote witnessing of wills was 5 to 10 years away from even being contemplated in Australia. And I'm not sure who would take me on my word now, because COVID-19 came along and we have Victoria that has legislation that allows both remote witnessing and electronic wills. And we have 4 other jurisdictions that allow for remote witnessing of wills. So one of the things that I did as a result of the changing position around the world with my colleagues who I sit on the STEP Digital Asset SIG with, is we published, STEP published this paper, which you probably can't see, but it's called Technology and Wills, the Dawn of the New Era, Special COVID-19 Edition. And what that paper does, it's a very detailed paper and it took a very long time to prepare, is it looks at the international position. It looks at what the UK are doing. It looks at what the US are doing, what Canada are doing, what New Zealand are doing as well, and each jurisdiction of Australia. And it went a little bit further in, once we looked at what each state and what each country were doing, it talked about the best practice guide. And lots of the questions that we've seen continually come up in each jurisdiction, regardless of what the regulations or the COVID special legislation is, are really similar practice guide questions for lawyers who are trying to offer remote witnessing or electronic signatures to create electronic wills. So we came together and I sort of consolidated lots of questions and tried to provide answers to those. So I would definitely encourage you to have a look at that, because it does answer a lot of the questions that we've received notice of and also that I've seen online. So I suppose the first thing that I want to point out is that there is a difference between electronic wills and remotely witnessed wills. And so each jurisdiction in Australia has different legislation, and Victoria is the only jurisdiction that allows for electronic wills, being a will that is signed using electronic signatures. Queensland doesn't have legislation which permits electronic wills. It has legislation that permits remote witnessing of wills where it requires a special witness. In New South Wales and in the ACT, they have legislation which allows remote witnessing of wills, but it does not require a special witness, and the two witnesses can be anybody who meets the formal requirements to be a witness of a wet ink signature will where the witnesses are physically present with the will maker. Australia's position, I suppose, and even when we compare with New Zealand, is the same that's happening in every other jurisdiction around the world. In Canada, each of the jurisdictions have created their own legislation, none of them which conform with the other. In the US, every jurisdiction is creating its own legislation based on their own statute and how they wish to implement electronic wills or remote witnessing of wills. And so I think that when we look at the international position and what's been happening, electronic wills and remote witnessing didn't happen in the world as a result of COVID-19. It definitely advanced the topic, but the US had legislation permitting electronic wills and remote witnessing of wills prior to COVID-19. Canada was contemplating introducing electronic wills legislation and remote witnessing prior to COVID-19, and the UK were also discussing it. Now, as I said, my 5 to 10 year projection of how long it would take Australia, the same thing has happened internationally, which is that COVID-19 has pushed everybody forward. And so when I suppose being asked to speak about the international position it was wonderful, and you may have seen me writing notes, Registrar Price, but it's because I'm very interested, and I will give the feedback of the experience in Victoria and the problematic legislation. Because from what I've heard from my colleagues who are practicing in Canada, they actually changed the legislation because it was almost impossible to comply with the legislation as it was drafted initially. And there were so many complaints and nobody was able to meet those requirements that the legislature went back and amended it in order to try and make it more accessible for the legal practitioners who were practicing in Canada. So I suppose that gives me a position to be able to say that I don't think electronic wills and remote witnessing will go away. Lots of legislatures are worried that we may be in a position and they want to be more prepared for any sort of lockdown, whether it's COVID-19 or another pandemic. And so they will start to revolutionise, and the discussions existed before. And I think the same way we've seen e-conveyancing shift the property law sector, I think that it is the way of the future, and people will continue to demand accessibility and the ability for people, particularly in remote parts of the country, to be able to access good advice and to be able to execute their documents. So I don't think they're going to go away. I think electronic wills and remote witnessing of wills are here to stay. I would really like to see some consistency between the legislation, but just like the inability for Australian states and territories to come up with a Uniform Wills Act, I don't think that we're going to see that anytime soon. So that's, I suppose, what I wanted to say about electronic wills and remote witnessing. And in relation to the electronic probate registry, we don't have an electronic probate registry here. And in speaking with the Registrar of the Supreme Court in Tasmania, the processing of electronic documents has been quite similar. We're quite lucky, like New Zealand and also like Queensland, in that we have only had relatively short periods of lockdown and been quite fortunate to be able to continue living our lives and seeing our clients. But what we do have in Tasmania is we have legislation under our Powers of Attorney Act and under the Guardianship and Administration Act, which provide that a power of attorney, enduring power of attorney, is only legally effective once it has been registered with the proper government department. And that registration process goes through the Land Titles Office, and there is a registry which we can search. So every power of attorney that is legally effective in Tasmania, and foreign powers of attorney, including powers of attorney from other states and territories, they can be registered here if a certificate is given, but we can search those. The same with enduring guardian documents, which regulate personal and medical decision-making in Tasmania. There is a separate registry that is maintained by the Guardianship and Administration Board with all legally effective enduring guardian documents. They're not without their problems, because just because it's compulsory that they're registered, it doesn't mean that they will be registered. But I think that with the Commonwealth's position about trying to implement a national enduring power of attorney register or a national power of attorney register, I think the only way that we would be able to do that would be to have a state-based registry that was able to be accessible from a national level. We don't have a wills register in Australia. We have private companies that provide the ability to register wills with them, the details of where the wills are stored. And that is also something that's happening internationally as well. Canada, the US, the UK, they have private companies that enable you to register your wills with them. The UK has a private company that has 8.4 million wills registered with their registry. But the only country that I'm aware of in common law jurisdictions that has government-regulated wills registry is British Columbia and Quebec in Canada, and those are regulated by the government, and it is very much based on the types of law that they have which regulates wills. Quebec, for example, the reason why they have such a widely used registry is because the use of notarial wills, where a notary will witness the will, and it makes the probate process much easier. So it's a lot of information, and I don't want to go over time because I definitely want to leave time for the questions. But it's an incredibly interesting space, and I think that the interest that we have had, and part of the reason why this committee was created by the Australasian Cyber Law Institute was because the only way that we will move forward, and the only way that we will get legislation and policy in place that will properly protect vulnerable people and will enable the rollout of electronic wills and remote witnessing, is if key stakeholders like the courts, like the legislature, and practitioners who are practicing with clients on the ground level and can talk about the problems that exist are involved, and we can learn from that experience.
Thank you very much, Kimberley. We'll move to our town hall discussion now. And I believe we've got a question from Angela Cox, who is just being brought onto screen now. Or is she? Well, I might take this moment, Kate, to ask you the question that I was that I had. With those 7 applications, was it the case that you had any video footage of either the signing or the attestation of those, and were they relevant in the informal will part of the application?
No, none of them had any. They may have recorded it, but none of them submitted the recording of the witnessing in relation to the actual application itself. But as I said before, it's not as difficult in terms of actually getting across the line with intent in relation to Section 9 for one of these wills that hasn't been executed according to the regulations correctly. As you would know, Paul, the further away it is from valid execution, the more difficult it is to actually prove intent. So the closer it is to complying with the regulations or the Act, it is much easier to actually show the intent there. I mean, they would have been able to say that this conversation happened. They explained that this is what we're going to do to witness. The person, the testator who's actually signing the will said, yep, this is what I want my will to be. I'll sign it now. So there's already some clear evidence there in relation to the fact that they intended to sign that document with the intent of that being their will. So it's not really, it hasn't really been an issue yet to see the video evidence. I think where it might become relevant is if they're having issues in terms of obtaining testamentary evidence as to testamentary capacity, then it may become relevant to potentially see the video then. But even then, it would probably still be necessary to get a doctor's opinion in relation to how that person looked on the video, rather than me myself assessing the testamentary capacity based on viewing the video, or the court themselves assessing the capacity based on the video.
Sure. So I think Angela Cummins is now online. So Angela, are you there, and would you like to ask your question? No? All right then. This is clearly demonstrating live the wonders of this new technology. We do have a number of anonymous questions, and in fact, one question has really come up a few times, and that question is there a chance, is there a chance that this legislation will be adopted permanently? That's really the million-dollar question, but let's throw it to the panelists for your opinions. Julie, I could see you shaking your head, so perhaps.
Yeah, look, I'm sceptical. I think it's still, in Queensland in particular, I just don't think it's been tried enough. And I think there's a lot of concern around the sorts of issues that Jenny raised, which is the disadvantages of not being able to see who's in the background, of not having the chance to really have that quiet conversation. I think that the current regulation we have in Queensland is likely to be continued on, given that COVID is still stalking us, I suppose. But I don't really see, unless it turns out to be a big success, which it really hasn't yet, I don't see it becoming something that is at the very least adopted greatly. And I wouldn't be thinking there'd be a big push for the legislation to continue, but that's just my view.
I think the situation in Victoria is going to be very different because we were in lockdown for such a long time, particularly stage 4 lockdown for over 100 days. I think that there was a much more use of the regulations when they came in. And I think that's going to potentially impact whether or not that actually proceeds in Victoria as permanent legislation. So I'm sure the government is basically looking at this now, because we've got only a couple of months until the regulations run out, and I'm sure they would be considering whether or not they want this to be a permanent thing. And I think they will be thinking that, especially now that a lot of solicitors have utilised the legislation, I think there'll be a lot of support from the profession, from council, from all different areas, lobbying government to say we need to keep this as a permanent option. I think particularly from an access to justice perspective, just like thinking about people that live in regional Victoria, you know, a lot of people that have to travel a really far distance just to go and see a solicitor and to get affidavits witnessed. From that perspective, it is quite good for the people like that to be able to have access to someone and actually get their affidavits witnessed quite easily. I will say though that personally, I'm not a huge fan of digitally signed wills, because I think there's just too many issues that surround that. And I think affidavits are fine, but wills, I think, have a lot more issues around them.
So I think I absolutely agree in terms of there have been problems with the signing, particularly with electronic wills and the use of electronic signatures as opposed to remote witnessing. And when I think about whether or not they're here to stay, I think it's definitely going to be on the agenda of many governments. I sit on a Elder Law and Succession Committee locally, and we've been asked by the Tasmanian government to consult on the Electronic Transactions Act and whether or not the restrictions which remove the execution of wills and powers of attorney documents which currently exist under the current regulations should be retained when those regulations expire. So I think one of the things that COVID-19 has done is it's put the discussion about particularly remote witnessing to the forefront of things to be considered, not only for estate planning documents, but for other documents. The Commonwealth Government took steps to amend the Corporations Act to allow company documents to be signed using electronic signatures. So much of the fear, I suppose, in implementing remote witnessing or even electronic signatures and electronic wills comes from fear of the unknown. And I was challenged at a session that I attended, and one of the questions, I suppose the challenge that was put to me was, when an elderly client attends at my office and I meet with them, I don't tend to ask them how they got to the office. I don't say, did somebody drive you here? Is there somebody waiting outside the building? And I wouldn't walk outside with them in order to see if there was somebody waiting outside the building. And when that was put to me in terms of a question, I thought, well, somebody assisting them to get to my office, driving them here because they're too frail to drive or they're too elderly, is that similar? And are we placing more emphasis on that because they are at home and we can't see them, or they may have helped them set up for the video conference? There is definitely policy and procedural documents, and it puts a lot more responsibility onto the practitioner. But I think in the same way that many years ago, hundreds of years ago, there were only oral wills. There weren't written wills, and we transitioned from oral wills across to wedding signature wills. And when you look, and one of the things that I look at in my paper was the criticisms and the fears that existed when we were shifting from oral wills across to written wills. And it compares those to the fears that we have now of introducing electronic wills or remotely witnessed wills. And they're very similar. So I don't think that it's going to be rolled out widely across every jurisdiction tomorrow, but I think it will be on the agenda, and it will be somewhere where we will move towards in the future.
I think just to add to that, I think my concerns are really much more from a practical perspective. So for me, as a registrar of probates, what constitutes the original will? You know, and how do we apply the presumption of revocation when an electronic will has been traced into the hands of a testator, and you know their computer has broken down and they've lost that original, but there's all these copies that exist with all the solicitors that might have witnessed it or with the witnesses that might have witnessed it. So just from a practical perspective, I think it's going to bring a lot of challenges, but exciting challenges, I think, in the next 10 to 15 years if we do see electronic witness wills stay around.
Okay, now I do believe that we have someone who's about to ask a question. Gennady Dobrinsky, are you there? You're on mute, but we can see you.
Yes, I think you guys should be able to hear me. And hi, Jenny. Thanks for all of your time. It's such great information you're all providing about your respective jurisdictions. It's just fascinating to hear as a solicitor predominantly practicing in probate and wills and estates. Well, my question's somewhat been answered. You've all addressed the pros and cons that you see of electronic wills. I guess I was thinking about some of the benefits that electronic wills could provide if, of course, they are accompanied by the additional evidence that you require in order to prove the validity of the will. I've been doing some reading, and it seems that in the United States at the moment, there's a few states which are currently allowing electronic wills to be probated in a standard fashion, as long as they are, and they're considered self-proving wills, as long as they are accompanied by affidavit evidence, which go to their execution and the custodian of that electronic document. So not really a question, because you guys have already addressed the questions I had, but I'm certainly, as a probate practitioner, really looking forward to the future, as I think it may even result in more evidence being created to show the testator's intentions.
Can I just say something about that? I actually have less reservations about electronic wills, ironically, than I do about witnessing by audio visual, because I don't really think there's much magic in wet signature, because most of us now wouldn't recognise a particular person's signature. But what I'm concerned about, and I take Kim's point about, well, how many questions do you ask? But I suppose working in court, you get a little bit, courts for such a long time, you get a little bit sceptical about the bona fides of a lot of people. And So for me, I actually don't. I think you can basically get around some of that electronic stuff, but it's still going to be the whole issue around somebody's testamentary intention, their capacity, and the how can you put it, the voluntariness of their commitment to that disposition of their estate.
Yes, of course. If somebody's in a solicitor's office, at least the solicitor is in a position to gauge their actual intentions if there's some other coercion perhaps that's at play. But of course,
there's nothing that's infallible, but I just think
that's
in terms of addressing the issue of the safe custody of electronic documents and the storage of them and the systems that are in place. One of my favourite pieces of legislation is the legislation or the statute that's in Indiana, and Indiana requires a custodian to be appointed of the electronic will. So they receive the original electronic will, and in the same way that legal practices around Australia have safe custody of a wet ink signature will that we're all used to, and we pass on, I suppose, and we have safe custody procedures relating to when those are transferred and who we can release those to, and if a law firm ceases to practice, where those wet ink signature wills go to. In Indiana, the system that they're trialling and they're trying to approach is that you do have a designated custodian of the electronic will, and that process is required to have formal handovers of those documents if the law firm ceases to hold them. So it's very much integrating law firms and legal practices and putting the onus onto practitioners to be able to retain those documents. But I think that that's one of the most important things, and I may seem to re-emphasize it, but there's so much material, and there's so many different countries, particularly the US and Canada, that have been looking at this system for so long. So they've been looking at what is the best system to implement and giving a lot of funding at a national level and in order to try and find a system that's appropriate and that deals with electronic storage of electronic wills and the execution of documents remotely, and whether or not Florida, for example, completely excludes vulnerable people from being able to execute their documents remotely. So if a person, and you're required under the legislation to ask specific questions, and if you answer yes to any of those questions, you can't execute the documents remotely. And the practicalities in speaking to court staff who process those is that who knows, and complex legislation means that there's more complex procedures to follow and more likelihood that there'll be mistakes. And the statistics coming out of Victoria are incredibly concerning in terms of the amount that just don't meet the complex requirements under the legislation, or what might not have been intended. I'm particularly concerned about the processing or the placing of the confirmation on the document, because that in itself is something that I suppose even people with the best of intentions would have thought that they'd complied with the legislation, but may not have understood the specifics of what was required.
Thank you very much for your question, Gennady.
Thank you.
We've got Naomi Guyot with a question.
Thank you, and good evening, everyone. Thank you to all of the panels for a fascinating discussion. I'm directed to target Registrar Price with some questions, and particularly around, I wanted to revisit what Paul had raised in the sense of those 7 applications, because clearly there will be more that appear before the court seeking a probate application. Thankfully, I suppose we've got Section 9 as our fallback, that if they haven't meet these strict criteria, that Section 9 could still be in our favour. But I'm wondering, with those 7 applications that have already come before the court, whether there was a common theme or a mistake where the practitioners perhaps who had been doing these wills, or if they were self-made, where they were let down by those regulations. I'm particularly concerned about, and echoing a lot of views of practitioners who specialise in this area, about that final requirement in the regs, which specifically is Regulation 41, subsection 5, subsections E to F, where it is that what I've nicknamed the pass the parcel approach, in the sense that it goes from the will maker around to the first witness, around to the second witness, and then back, this is the next reg, back to the will maker to have a statement written on there. So there's two parts to my question. One is, were there any common mistakes that you've seen then as a common recurring theme in those 7 applications? And secondly, if the registrar could very kindly provide perhaps some court guidance to practitioners about what that regulation means where it says write a statement, because there hasn't been any guidance from the LIV or the LPLC about what constitutes writing a statement, whether you would accept a handwritten comment from the will maker, or whether it's pre-typed for the solicitor to help the client, and then it's duly signed and dated in accordance with the regs. So I'd be very interested to hear the registrar's response to that. Thank you.
Yeah, so I think I mentioned when I was speaking before that has been the regulation, the particular regulation, it has not been complied with. And that's because that statement has been lacking in entirety, not because the statement has been completed incorrectly. And I think there was a lot of confusion because I think a lot of people were sort of thinking, why would it go back to the testator for them to make that statement rather than going back to the solicitor, when the solicitor is the one that understands that the regulations have been complied with. And it's not necessarily the testator that can say whether or not the regulations have been complied with. But I think, and I must say that I haven't had to yet consider whether or not what writing actually means. But I think it is probably something that's going to have to be referred to the court if we do get one that doesn't actually have physical writing on it and it is typed. And it will have to be something that is judicially decided in interpreting the regulations. I don't think it's something that I'll be able to actually determine myself. But what I can say is I believe the intention of that part of the regulations is so that there is one copy that is endorsed with that statement, and there's only one copy. And from my perspective, if I was the person that was doing it, and this is not court guidance, this is just from my own personal perspective, if I was the one that was having a client witness do a will like this, I would suggest to them that it would be best for them to print off a copy, make that statement, and then sign it physically. And that is just from my perspective, because I think you're going to have the least possible issues. The couple that we've had that have actually complied with that requirement under sub-regulation F have actually done exactly that. So the ones where we have had people that have actually had that statement on there, they have actually had printed copies that have wet signatures and actually physically written on there what is required under the regulation. And that's why I haven't had to consider yet whether or not writing would include typing with an electronic signature. So it's something I think that will, as I said, will probably have to be determined by the court when and if it does actually happen. I know that probably doesn't answer your question.
No, look, we're all in new territory here, and you know, we're trying as practitioners, we're trying to do the best we can to interpret what that means. But certainly from a practitioner perspective, that final requirement has become very cumbersome for Victorian practitioners. I'm not aware of any other state, although Queensland seem to be talking about a certification type process, but it's certainly...
The Queensland regulations or act is quite different in terms of I think it's much more clearly set out exactly what needs to happen. The regulations here, I think, are very clear that signing can be done electronically, but there's nothing clear in the regulations that says writing can be done electronically. And I think that's where the issue arises, because, you know, it's not defined there that writing means by electronic means doesn't necessarily mean you can type. It is clear that a signature can be done by electronic means.
Look, I think one of the best things, Naomi, I know you're asking Registrar Price, but I think one of the best things that's been done, the most helpful thing that's been done here in Queensland is the Law Society itself, basically giving people a precedent of how to do things and what it should look like. And I don't know if that's something that's worth considering for your profession, your part of the profession.
There's certainly some lobbying that's been done from various groups at the LIV, and certainly this committee itself, of which I'm a member, EWOWC, that we're trying to look at whether or not those regulations can be amended and or reviewed if they're going to be in fact extended again in April. And if they become permanent, of course, then that will be something that will still need to be clearly addressed, because it's something that is very ambiguous at this stage for practitioners down here. Yes.
And I can say the court will give that feedback to government when requested. Just the feedback that it appears that has been quite difficult for practitioners to comply with the regulations as they're currently written.
As you've indicated, it would make more sense for it to be sent back to the practitioner, and that could then be the final version, that is perhaps in a hard copy sense sent off to the court eventually for probate applications when they become live.
The difficulty becomes under the current regulations, there's no requirement. I recall Julie was saying that there's a requirement that there's a special witness in Queensland, which has to be, for example, a legal practitioner. That requirement isn't in our regulations. So theoretically, the witnessing, an audiovisual witnessing of a will can happen with lay people. Yes. And that's where it becomes difficult, because who do you then give it back to say that the regulations have actually been complied with, which is why I actually quite like that idea of a special witness requirement that Julie mentioned that has been reinstated in Queensland.
And just to add to that again, there's another complication if the will maker's not actually in the state. So the regulations don't suit or address that sort of a scenario if they're perhaps trapped or outside of our border, and yet they are normally a resident here and has assets here and want to make the will here. The regulations don't provide for that scenario either, and in fact we'd be back to Section 9.
well, the problem is the regulations don't specify what specifically is the place of witnessing in that situation. Is it Victoria where the witnesses are, or is it the other state where the person is? But I guess you've got to think about the Act actually covers that in terms of where a will is executed in a foreign place. If it's executed according to the place of domicile of the person, then it is still a validly executed will.
Thank you.
So potentially you can get around it by using that.
And on that issue, in terms of one of the other issues that I've heard that has been experienced internationally, but also questions that have been raised, is even where documents are executed out of jurisdiction. So if somebody wanted to rely, they had their assets were predominantly in Victoria and they wanted to execute the documents, or they were in another place and they wanted to execute their will under the terms of the Victorian regulations. One of the most important, I suppose, practice guide points that has been put out across the world has been ensure that your witnesses are in the same jurisdiction as the will maker, because not having the will maker in one jurisdiction and one or both of the witnesses in a different jurisdiction can cause issues based on the situs of where the will was executed. So that, in terms of the ability to execute documents under the Victorian legislation or any statute that provides for remote witnessing, one of the most important things that we're seeing now is make sure your witnesses are at least in the same jurisdiction as the will maker.
Thank you very much for your question, Naomi. And I think that we've answered a few other questions that have come in anonymously to do with Regulation 45, subsection 5F, and also to do with interstate either signing or witnessing. So I'd like to invite now Karen Finch, who has a question for the panel.
I do. Thanks so much, Paul. And thank you for everyone. It's been really fascinating to hear this. I'm coming into this discussion in a bit of a different way, not as I'm a non-practicing lawyer, and certainly wills and estates was not my area of expertise when I was practicing, but I do have an online legal marketplace where I speak to consumers day in, day out about connecting with lawyers and engaging lawyers for legal services. And when COVID hit, and I'm based in Victoria, when COVID hit, we had people bombarding us with requests to get their estate planning. It wasn't just the elderly, it was people in their 40s, it was people locked in their homes who wanted to be able to get their affairs in order. And then they were being told that they had to do things like, throw a document over the fence and get their neighbour to catch it, to then witness it, or go through some drive-through, so potentially break down lockdown rules to go and do a drive-through in a car park. We had some of our lawyers saying that they were being forced to kind of drop documents on doorsteps, run back to the car, you know, watch as I mean, it was just really, really ridiculous. And obviously, you know, I wanted to just make the observation that we know, I mean, and this is as a general, not just in estate planning, but we know that 70% of people who have legal needs don't go and see lawyers because they can't access them in a way that's convenient to them. And given that we are a service industry that are trying to service clients, you know, I just wonder that sometimes we always talk about these situations in relation to protecting lawyers and to protecting, you know, our indemnity and our professionalism, you know, the liability of where we sit. But when you've got clients crying out to be serviced and for that peace of mind and to have these documents put through, it just sometimes seems we focus on that very minute, I guess, part that, you know, there's some sinister something going on. The other thing I just wanted to add is, you know, the younger generation coming up, they find their soulmate using technology. They are going to want to access their legal services using technology. You know, we've done lots of surveys with the younger generation talking about their appetite for, because they are a very informed and educated bunch, and they would use legal services more if it was more convenient for them to access it and do it in a way that they're very savvy with. But also I just wanted to ask whether or not, I'm also the Vice President of the Australian Legal Tech Association, and we've got legal tech companies that would love to work with practitioners and with the legislators and with the registrars and the law societies to come up with really robust solutions to this. So I just wanted to throw out those views there. Probably not too much of a question, but just to kind of put the client voice in there.
Right, well, does anyone want to comment on that?
I just want to reinforce that I 100% agree, and I think that engaging tech companies in order to try and find solutions is one of the first steps that we have to take, because your DocuSigns and Adobe Signs and PandaDoc and all of the different electronic signature documents and even audio-visual technology, it wasn't set up with key considerations of the complications that estate planning documents bring. Contracts, affidavits, so many different documents have different execution and more simple execution requirements than estate planning documents have. And so I think that involving tech companies in order to try and find robust solutions to provide that protection for vulnerable people is something that I think it's going to happen, fingers crossed, that it does happen. But I think that is definitely the way of the future, and how to ease the concerns of key stakeholders about the risks that it poses, or the complications and difficulties that it poses.
Thank you very much for your comment, Karen. We have one final question from Daniel Harrison, who's a colleague of mine on Young's list.
Hello. I just want to follow on from something that was said earlier, and also picking up something that Karen said. And it's the vexed question of whether or not this continues in the future. We do everything online nowadays. You know, we do settlements of property nowadays, something that would have been unthinkable 20 years ago. We buy everything online. We get our groceries delivered from a supermarket online. We live online. We fall in love online. There's no magic to a signature. It's not something that has to be written in blood. Once upon a time, we had to sign, seal and deliver, and literally put a seal on a document. And if you didn't literally have a seal, a document was invalid. And we've moved on. You no longer have to seal a document. Does it make a document less enforceable? Well, no. Are those who say we're going to go back to the old days, this is all very terrible, aren't they just naysayers who don't realise that the world is moving on? I'm not being critical here. I'm sort of stirring the possum more than anything. I mean, isn't it inevitable that more and more will be online? Why can't people keep doing this?
I actually think it's really interesting what you've raised, because what I have seen is from my own experience, I'm speaking to people that ring up, is that a lot of people, even though this legislation is in place and even though you're able to do this, a lot of solicitors are very reluctant to use the legislation and to use the regulations. They're reluctant to audio-visually witness affidavits. They're reluctant to audio-visually witnessing wills. And on the flip side, you see that with clients a lot as well. There's still a lot of people out there in the community that just don't like the idea of doing an audio-visually witnessed will. They would much prefer to meet in person in an office and actually physically sign something. So I think even if these regulations and the come into place permanently and the legislation changes, I think what we might see is that it is a bit of a generational thing, and it might take, you know, 10 years for everyone to get really used to the idea that you can do a will electronically and that you can do all these other documents electronically. And I think it's just a matter of getting people to change their frame of mind in relation to what actually signing a document means. But yeah, I think that it's probably the way of the future, and I have no doubt that this is going to be around for some time, but I think it's going to take a while for everyone to just get to the point where they're comfortable with it.
Yeah, look, can I just add, as I said to you before, I have less trouble with electronic signatures than I do with some of the other aspects of remote witnessing. And the difference between falling in love online is that, frankly, a lot of people don't seem to take that as seriously as they do their estate. And I just think there really are genuine issues which on a policy level we have to work through before we can just, because it's not just a simple matter of how you sign or whether you do it remotely. It's really a case of, are there competing demands that you've got to square away? And I think there are some real issues with estates. We see some of our most disgraceful behaviour when it comes to what people do to get access to estates, because they're actually often the most money a lot of people are ever going to see is an estate. And I think that's part of the issue, is really there are other competing policy considerations we've got to work through.
In other words, wills are just so important that you can't in the long term pandemic aside do other than have it the traditional way.
No, I don't think that's right. But I think there are genuine issues that need to be, it's not as simple as, do you do it electronically? Do you care about real signatures? I don't care about real signatures, but I do think there are real issues about people being taken advantage of, undue influence, various things, which when it comes to estates, as I said, you see some very dreadful behaviour.
And all of the protections would still exist in terms of the ability to challenge the validity of a will. And we're not saying that, I don't think that the future will only be electronic and we will move away from wedding signatures completely. I think it will be a combination, and most definitely a generational thing in terms of who chooses to complete them and come into the office. In the same way that, you know, will lawyers be replaced by artificial intelligence? Anyone who works in the estate planning industry will say, until we have real artificial intelligence who's able to deal with emotions and completely unreasonable and unrealistic requests that we receive when somebody wants to draft their will, you will always have that one-on-one service where clients have complex circumstances and need that one-on-one advice. So I think that it's very much, as I said, I quite like the Florida legislation, which precludes vulnerable people from being able to, and they have a definition of who vulnerable people are, but it precludes them from being able to have the documents witnessed remotely. And in terms of the checks and balances, it is a time thing, and I don't think that any model has it completely correct. But moving forward, we hopefully will find some way and some groundwork in order to achieve an operational system.
Thank you very much for your question, Daniel. We better wrap things up. I'd like to sincerely thank our panel for speaking today, and in particular, Registrar Price. I'm sure that you're very busy in your first few months as the new registrar, so thank you for sharing your experience and insights with us. And I'd like to thank everyone sincerely for coming and remind you to join the Facebook group if you haven't already. I'm sorry if we missed your questions, but I'm sure that someone will be there on the Facebook group to answer it if it wasn't answered tonight. And I'll just hand it over now to Carol for the final thank you. No.
Well, thank you so much, Paul, and thank you very much, everybody. What a fabulous hour and a half. Clearly, electronic witnessing and wills is not something that is per se, or, you know, something to be only read and dealt with by a more boring sector, perhaps, of the legal profession community. How has the time flown so quickly? So we cannot thank Registrar Price enough for her insights into Victorian probate practice through COVID and her guidance about what she hopes to see from us going forward. Executive Director Steele, thank you for sharing Queensland developments in all systems electronic and COVID practice. We look forward to observing your future developments and change over time. We hope to have attracted at least one of your number from Queensland to EWOWC to keep us informed of the future steps that Queensland takes. Kia ora, Jenny. It's great to see the past honoured modern practices in Aotearoa and their ability to adapt when the nation calls for it. We hope you'll keep us up to date with how estates and probate practice looks to all things electronic as it continues to develop. And thanks to Kim for teaching us how progressive Tasmania can be. Frightening that you're so advanced and we're catching up. Such smart innovation can be simply done to ensure the safety and validity of instruments needed by the vulnerable. And with all of those developments in the common law world using wills banks and other forms of registries for their estate instruments, so the testator and other parties and their families know where to find documents and what to do when the time comes. I'd like to thank Paul for doing a great job as our moderator, helping everyone to feel at ease and assisting the audience to have their question asked and answered. And as Paul said, for those that we didn't quite reach, we look forward to interacting with you on our Facebook group. It will be remiss of the current EWOWC not to thank our past chair and co-chair Peter Moran for getting together the founders of EWOWC, including Naomi Guyot, Inez Calwait and Lucy Percy of Heads and Heart Lawyers. We wouldn't be the same without your contributions. We close with a special thanks to our sponsor Young's List and a dedicated and dynamic list of Victorian counsel practicing across all areas of law, including wills, probates and estates. And lastly but not least, certainly Karen Finch, you've been a dynamic help to all of us and at EWOWC, and we look forward to talking with you in the future about tech and law and the consumer perspective. Thanks so much for joining us this evening. Keep an eye out for our next webinar event on 14 April 2021 about technology in the wills and witnessing space, and our first live demonstration CPD on 10 March 2021 from 5:45 at the Northern Suburbs Law Association, hosted at the Veneto Club at Bulleen. We look forward to seeing you there. Thanks everyone.